As IT security professionals and for the system, you need to know how the laws work that impact your job. You need to know the different types of laws, the difference between them, and what falls in which category. Criminal law is the most used law for cybercrimes. Society in general is seen as the victim, and it has a very high burden of proof. Proof must be beyond a reasonable doubt. But then the punishments are also the strictest. It can be incarceration, which is prison, death sentence, or financial fines, and the point is to punish and deter others from doing the same. I've had some of my students question if we actually use the death penalty on hackers. And in general I said no, but it is an option. While it probably won't be an option if you steal credit card numbers or social security numbers, hackers can still crash a plane or cause a nuclear power plant to melt down. They can kill hundreds, thousands, or millions of people. In those cases, death penalty would definitely be on the table. So yes, it is possible, but it is unlikely. Secondly, we have civil law, also called tort law. For civil law, individuals, groups, organizations are seen as the victim. And in this, proof must be the majority of the proof. And the punishment here is financial, to compensate the victim or the victims. In some cases, cyber attacks or hacking can fall under this category, but it's rare. The third type of law you need to know is administrative law or a regulatory law. These are laws issued by government agencies. In the US, that could be FDA rules or HIPAA, which outlines how health information has to be handled, who can have access to it, and how secure it is. Proof for administrative law has to be more likely than not, and in most cases the punishment is administrative and/or financial. If an employee in our organization unknowingly exposes HIPAA data, they might get a reprimand. If they knowingly do it, they might get fired. If the company loses HIPAA data because we didn't do our due care, there would most likely be financial consequences. We'll cover HIPAA more in depth later. And then finally we have private regulations. An example of this could be the PCI DSS. It's a set of regulations that the payment card industry has agreed upon, and if you want to use payment cards or issue payment cards, you have to agree to them, adhere to them, take part in the audits. There can at times be financial consequences if you don't, but in most cases you'll just get excluded from handling or issuing credit cards, which in itself is a big enough incentive to follow the rules. There's also some key terms you need to know for the exam and for your job to ensure that you're doing what you're supposed to be doing. The first is due diligence. Due diligence is you doing your research before implementing or adding anything to your network. Before implementing a solution or adding hardware, software, or any changes to your environment. It's researching the best practices, how it's recommended. It's you researching, if we do the ideal implementation of this product, we would do it like this. It's having the knowledge to do it right, which then leads into due care, which is actually doing something. Having all the knowledge and doing nothing about it means nothing. So in due care, or the prudent person rule, what would a prudent person do in this situation? And prudent really just means someone who does the right thing. You've done your due diligence, now you act on it. This could be implementing the right IT security architecture, making sure your systems are patched, or if we're compromised, you fix the issue. You notify the people who are affected. You do the right thing. Which then leads us to negligence, or gross negligence. That's really the opposite of due care. This can both be you having the knowledge, having done your due diligence, but not acted on it, or just completely ignored it. You didn't do the research, you didn't implement anything, you just ignored it. If you're negligent, you're probably also liable. And if on the exam you see a liability question, look for the indicator. If it is ultimately liable, it's senior management. That doesn't mean you're not liable. It just means that since they make all the high-level decisions, they're in the end who is responsible. How we handle and obtain evidence when we've been breached, both during and after the attack, is very important. If we want to have any chance to prosecute the attacker, we need to obtain and handle the evidence just right. And we also need to know the different types of evidence. Real evidence is physical, tangible objects. It's things you can touch. Most commonly in IT security, it's the hardware, the USB drives, the hard disks. It's not the data on them. It can also be other things from the attack as long as they're physical. It can be fake ID cards. Just remember, real evidence is physical. Direct evidence, on the other hand, is something that someone experienced. It's from a first-hand witness and something they experienced with their five senses. Something they heard, something they saw. If it's something they didn't experience themselves, it would be hearsay. Circumstantial evidence are facts in themselves, but they're not strong enough on their own to be real evidence, but they can be used in support of other evidence. Circumstantial evidence can have more than one explanation, but it can help in proving why something did or did not happen. and then similar collaborative evidence. In itself, it's not a fact, but it supports the other facts of the case. If your green car has a dent in it, and my bumper has green paint on it, that could be a collaborative fact. It's just there to support some of the other facts of the case. Hearsay is something that you don't have first-degree knowledge of. You heard about it, you were told about it, you didn't experience it. In general, it's not admissible in court, but there are some exceptions we need to be aware of. Computer records and logs are considered hearsay, but case precedents and updates to the Federal Rule of Evidence has changed that. Rule 803 means that data or logs collected at the time or near the time of an attack can be admissible. But like any other evidence, we need to have a clear chain of custody, and any logs and data would need to be hashed so we can ensure the integrity. In a court setting, we obviously want our evidence to be accurate, complete, relevant, authentic, and convincing. That's called the best evidence rule. The better evidence you have, the higher chance you have of conviction. However, us being in IT, our evidence normally falls under secondary evidence. This is where logs and data from the attack would be. And it's very important that we keep the integrity of the data intact. If there is no clear chain of custody, or we can't provide the hashes we did before and after analyzing the data, it's very likely it will be ruled inadmissible. If we take the example of a hard drive, we would probably remove it from the system, put it in a write blocker, and make a hash of the entire drive. We would then make a bit-level copy of the entire drive, hash the bit-level copy, make sure the hashes match, and then do our forensics on the copy drive. The compromised drive would be placed in an evidence bag, sealed, and have a clear chain of custody. Once we're done with our analysis, we would ensure that we do another hash of the copied drive and that all three hashes match. If they don't, we missed something. We altered the data. It's not admissible. And hashing is done just to ensure the integrity of the data. If something was changed, we would have no clue what was changed, just that something was. And for the original drive, we'd keep a complete chain of custody. Who handled the drive? When did they do it? What did they do? Where did they do it? And we handle the actual drive as little as possible. In actuality, once we've done the bit-level copy, and the copy and the original drive's hashes match, we shouldn't touch the original drive again. While the system certification is an international certification, there are some US laws and regulations you need to know. For your job as an IT security professional, it's important you know the laws and the rules in your area, your industry, and your country. If you don't know them, how can you follow them? The US laws we're going to be covering here have similar counterparts in the rest of the world. Some places they're stronger, some places they're weaker. For the exam, know the US ones you need to, but even more important, understand the concepts behind it. The Fourth Amendment of the United States Constitution protects citizens from unreasonable searches and seizures by the government. Whether the search or seizure is unconstitutional is for the courts to decide. In most cases, they would have search warrants or something similar that allows them to search your house, your computer, or whatever they're looking at. If they do not, most likely the evidence will be deemed inadmissible and not allowed in the case. There are, however, exceptions. The main exception you need to know is exigent circumstances. This applies when there's an immediate threat to human life or evidence destruction. But it only applies to law enforcement or those operating under the color of law. Under the color of law just really means someone who's employed by the government. This could be off-duty police officers, judges, prosecutors, even in some cases private security guards. Regardless of who they are, the legality of the exigent circumstance would be determined by a judge. If they determined it wasn't obtained legally, it would be inadmissible in the case. The Fourth Amendment also carries over to your employees. If they're not told and have agreed to all their actions being monitored, you're not allowed to. And furthermore, you can't use it against them. Many organizations have a form that employees sign when they join the company, saying that they're okay with it, they're okay with their actions being monitored, but just make sure that it's legal in your state, country, and county. You should also clearly understand what the difference between entrapment and enticement is, when it's appropriate to use and when not. Entrapment is both illegal and unethical. That's when you convince someone to commit a crime that they weren't planning to commit already. To make it very clear-cut, if a police officer talks someone into committing a bank robbery, that's entrapment. They weren't planning it already. Where the other side is enticement, that's considered both legal and ethical. They have already decided to commit the crime, you're just making it a little more interesting. The way we would use it will often be honeypots or honey nets, which is a server or network of servers that look like your real network, your real data, but it's completely separated off from your regular network. It's only there so we can learn what kind of attacks would be used against us, so we can put in countermeasures against them. If we leave certain vulnerabilities open on the honeynet, that could be unpatched systems or ports that are open, that could entice attackers to attack it. Whereas if we told them, hey, there's all this great credit card information over here, you should attack it, that's entrapment. On the legal side of it, if the defendant can prove that they were entrapped, that's a solid legal defense, the case might get thrown out. Whereas if it was enticement, it's not a solid legal defense. And there is some gray area between entrapment and enticement, and ultimately it's up to the jury or the judge to decide which side it falls on. Before you start deploying honeypots or honeynets, check both with your legal department and senior management, because they can cause both legal and practical risks. Just as anything else we do our due diligence and our due care.